Mr. Szabo, the GDPR is posed as protecting the data of European citizens, and there's a lot of self-congratulation going on here today. But for all its good intentions, it's had a hugely adverse effect on small and medium-sized businesses and also on charities and civil society NGOs. The EU's failure to have any level playing field means that large, wealthy multinationals and tech giants with their armies of lawyers and oodles of money are put on an equal footing with small organisations who are just trying to keep in touch with their networks and build support for themselves. And then they face the same draconian penalties and enforcement. Well, you boasted you'll enforce. It's created jobs for lots of consultants who charge a fortune offering advice on this terrible GDPR, making it one of the most hated pieces of legislation in the UK. So how can you assure me that protecting privacy doesn't lead to over-regulation, as the EU always tends to do, and strangles innovation of small businesses and actually denies freedom to small civil society organisations just mobilising?
Mr. Szabo, over to you for the next 2 minutes.
Thank you very much for this question. Indeed, when the GDPR was still a draft, one of the key messages was to avoid additional administrative burdens. That was something the legislator was really striving on, and it is indeed mentioned as a backdrop of the GDPR. I would like to mention that the review and evaluation of the GDPR is ongoing, so I am sure that this aspect, additional administrative burden, will be one of the aspects to be taken into consideration by the Commission. If it comes to smaller organizations, I understand and I also know this problem that smaller organizations need help in putting the GDPR a daily reality. I would like to mention here that, for example, the Hungarian data protection authorities and other authorities have a program, a project for SMEs, small and medium-sized enterprises, have a hotline to call or to email us, and we collect the questions, the inquiries of them, and also the worries, whether what is difficult for them regarding the application of the GDPR. We will summarize all these inputs and we will publish it in a document. So in brief, I can mention these aspects, and indeed, you know, the less and less administrative burdens will remain a goal of the legislator and also, obviously, the supervisory authorities.
Mr. Wiewiórowski, one of the greatest threats to privacy as a civil liberty today, it seems to me, is that dread phrase, nothing to hide, nothing to fear. And actually, it's fear and often scaremongering, whether it's about national security or cyber security, that's led many member states' governments and EU bodies, in fact, to breach individuals' privacy by mounting surveillance and casting suspicion on anyone with secrets, something to hide. Demanding, for example, that technology companies hand over encrypted private messages, such as the debates around WhatsApp and the idea that there's all these people having these secret messages against the state, does actually, it strike me, be one of our greatest threats. I was just wondering how would the EDPS counter such fear-mongering politicians spying on their citizens? Can you reassure me, with your background, you must know that having the government spying on your secrets is not a comforting thought?
Your answer, Mr. Wiewiórowski.
There would be actually two kinds of answers and two groups of answers, depending on if we are talking about the national security or if we are talking about the cyber security, because you took actually both of these fields in the same question. While there is a huge difference between them from the purely formal point of view. And I would like to see the very strict border between the things which are in the national security sector and which probably should be addressed differently by the EU institutions and EU law, and the things which are in the public security and in the cyber security. I would like to propose probably that since we agree year after year about the new ways of the surveillance, which is somehow accepted in the European Union, let's make it in the innovative way. And for one new element that we propose, let's remove one of the old ones. If there is something which is still not effective, and we will try to propose something instead of that, let's propose instead not on the top. Because that's time after time we have a situation where EDPS is coming to the Parliament or to the Council or to the Commission and is saying, now we are talking about this step, and in 5 years we will come back to talk about another step. So if we talk now about interoperability, what will be our discussion in 5 years? Because we will not go to do the step back. So that's something that I would like to, that's not a joke, that's not an anecdote, that's a proposal. Let's assess if the things that we did so far are really enough to be kept. And of course, when I said that I remember the times when I was lacking the values, I especially meant the surveillance by the state. And that's something which I was keen on from the very beginning of my work in the public sphere.
Mr. Badova, I'm with you on IT engineers and on research. Good on that. But to move on to politics, sometimes there appears to be a clash between the right to privacy and data protection with the values of free speech. And I do worry that both data protection and privacy are becoming a linguistic trick to justify the creation of new mechanisms that will curb our right to free expression. I wondered if you could comment on something I'm really worried about, which is the problematic right to be forgotten that allows individuals to request the erasure or removal of publicly available information about them deemed offensive, where individuals can demand the removal of what they say, posted on Facebook, and now backed by the ECJ and the full weight of the law. It does seem to me that the EU is in danger of setting up a great firewall around Europe in terms of data protection, apparently, or privacy, similar to China, dictating what others have access to on the internet, demanding the removal of offending material worldwide. So I just want to know how the EDPS would uphold the rights of individuals to voice their opinions, have access to maximum information, and prevent privacy laws from extending into the realm of free speech.
Thank you. Sorry. Thank you, Madam President. It's true that the discussion of the territorial scope of the right to be forgotten and the very essence of this right can enter into conflict with the right to access information and to have, free speech. This is why the question of the territorial scope of the right to be forgotten was so critical before European Court, because should you have extraterritorial reach, you would have the risk to have countermeasures from other states that are not democratic, that would prevent European citizens to have access to information. So the risk of having a too broad and universal scope of the right to be forgotten from a European perspective would be to have some drawbacks and some backlash from other countries that are less democratic, and that would prevent us from accessing information. So I think that the European Court of Justice has reached a fair balance and strike the right balance between access of information and right to be forgotten, because it's also an important one in stating that whenever the content has to be the index, this is what the right to be forgotten is about, it's not that the content is deleted, it is de-indexed from search engine. Whenever it is granted, and you have to grant it, it should be on the scope of the European territories, eventually based on geolocation, so geo-blocking measures, but not for an extraterritorial and universal reach, because, as the Advocate General said, that would risk to endanger the access of information from European citizens and the risk to have retaliation to some extent. So I think it's a fair balance, and this is why my studies and my articles were about to try to preserve the right of free speech and access of information, not at the detrimental of the right to be forgotten, but with a fair balance that would not have a diminishing common ground for access of information.